Okay. Morning, Mr. Reedy. How are you?
Morning, Judge. How are you?
Good. All right. Good morning, everybody. My name is Judge Kim Teresa Malika. You're in First Appearance Magistrate Court. Today you're going to be informed of the charges and we're going to determine if there's probable cause. Today is not your trial day. Please do not talk about the facts of your case. Everything's being recorded. You also have a right to an attorney. We have Mr. Romero at the main jail and we have Mr. Reedy to my right in the courtroom from the Public Defender's Office. We have Assistant State Attorney Eric Linder and we have Sharika Ross from the Clerk's Office. All right, so let's call, I just have one, I don't know where it is on the docket, but it was taken out. So it's Jordan Harris.
Judge, good morning. Bill Dorenzo. I'm actually here on behalf of Mr. Harris.
Good morning. How are you? Do you need time to talk to him?
No, I don't think so, Judge. I've seen the affidavit. I've seen the allegations. I don't think there's going to be much we can do this morning other than the court making a probable cause determination.
Yeah. So, Mr. Harris, you have 6 counts of probation or community control violations. You're going to be held no bond. So, normally, it would have a date on here for the clerk's office. You might want to call up Judge McCarthy and tell them that they should set it for tomorrow morning.
I will.
Okay?
Okay.
Thank you very much. All right.
Judge.
Thank you, sir.
Okay.
Do you need to talk to your client?
No, I'll see him tomorrow.
All right. Thank you. Okay. What about Anton Tuff? That's a Judge McHugh case.
No, it's technically going to go before Judge Cohen because he's that felony DOP.
Oh, he does. Okay, I see. All right, so let me just... Because I saw it on the docket, it was under the misdemeanor, so let me tell her.
Correct. He is here present, Judge, at Maine.
All right, so Mr. Tuff, you have a touch or strike battery, domestic violence, and then you also have a probation violation or community control. Court does find probable cause. Court's going to order no victim contact, direct or indirect, with the alleged victim with the initials DRS. Well, I take that back. I will allow, or we can talk about email contact, since they have a child in common. So, what say you, State?
Well, first, if the court's going to allow contact regarding the child, I'd ask that it be through a third party and not directly through email.
Okay, I thought this was the mother.
Bless you. It is the
mother. The initials.
No, it is the mother of their child in common, Your Honor.
Okay.
With that being said, I'd still be requesting contact you through a third party.
Uh-huh.
Considering the allegations and the fact that he is on probation out of Dade County on a violent felony offense, I'm requesting a $2,500 bond.
Okay. What say you, defense?
Judge, we're not far off. This is a misdemeanor battery. I'm going to be asking for a $1,000 bond. Mr. Tuff, I did explain to him he's not going to have any sort of contact. He assured me that's not going to be a problem. They do live separate and apart from each other. He's going to maintain that and have no contact except for purposes of visitation. We wouldn't have an objection as far as through a third party to make sure that there's no sort of contact between Mr. Tuff and the alleged victim. He is currently working. He works at Taco Bell. He makes approximately $8.50. He lives in Hallandale. He lives there with his grandmother. That's who he's going to be reaching out to help post his monetary bond. I believe their monthly rent is approximately $850. So he's going to contact his grandmother to help post his monetary bond so Dade County can pick him up. He believes his grandmother can afford about a $1,000 bond, so that is the reason why we're asking for that amount, Judge.
All right, so $1,000 bond, no victim contact, direct or indirect with DRS, except third party for child issues via email and text, no possession of any firearms, ammunition, or weapons.
Thank you, Judge.
Thank you. And he's to maintain 500 feet at all times. Alexandria Tate.
Ms. Tate, come on up, please.
All right, good morning, Ms. Tate. You have an out-of-state hold, no bond hold for a felony out of Ohio for a forgery. We'll see you in extradition court Tuesday or Thursday at 1 p.m. Thank you. Ryan Barney.
North Broward, good morning.
North Broward, good morning. How are you?
Good morning, Your Honor.
All right, Mr. Barney, you have an out-of-state hold as well. It says out of Pennsylvania. Counterfeit possession. Don't talk about it.
No, I'm sorry, that's my brother. I'm Michael.
All right, so, all right, let's recall your case. We gotta wait till confinement gets here. Thank you. James Turner.
North Broward.
North Broward. Mr. Turner, good morning, sir. You have an out-of-state hold as well. At a Missouri absconder from the Missouri Department of Corrections. You have a no bond hold. We'll see you in extradition court Tuesday or Thursday at 1 p.m. Good luck to you, sir. The court finds probable cause for your arrest. Anna Smith. North Broward. Good morning, Ms. Smith. You have an ad charge, trespass, conveyance. It's a $1,000 bond. It's a capias. The court does find probable cause. What say you, state? No return to where?
Oakland Park.
Don't discuss the facts of your case, Ms. Smith.
It's involved a 7-Eleven at 3800 North Andrews in Oakland Park.
All right, ma'am. So what say you, defense, with regard to the bond?
Judge, I'd ask you to leave the bond in place. I spoke with Ms. Smith. She indicated her mother is going to be able to bond her out.
All right, no return to the 7-Eleven, ma'am. If you go back there, you'll be arrested.
Yes, ma'am.
Holly DeLaro, please. Holly DeLaro.
She's here present, Judge, at Maine, and she is approaching.
Okay, Maine Jail. All right, Ms. DeLaro, good morning, ma'am. You have DUI, alcohol, or drugs. First offense, $500 bond. Count 2 is DUI, unlawful blood alcohol level, .15, $1,000 bond. And then you have possession of open container in a motor vehicle. Does she have any prior, state?
Your Honor, I'd have to check, but even so, even if there aren't any, I'm very concerned about these allegations. According to the statement she gave from law enforcement, she advised she started drinking 3 hours prior to her arrest. She advised that she drank 2 liters of vodka. This arrest was about 3 o'clock in the afternoon, and her breath results were a .343, .357.
Okay. Does she have any priors?
I'm checking that right now, Judge.
Thank you. All right, the court does find probable cause for her arrest. Total bond is $1,500. What say you, defense? She does have a high reading of a .3. Just
I understand that, Judge. My understanding is
.343 and .357.
I understand that, and I believe that's why the state brought that to attention. And but Ms. Lara did advise me she has a clean record. She is a single parent, Judge. She basically takes care of her kids. Right now she's living in North Miami with her parents, so the kids are with their grandparents right now. She's a stay-at-home mom. Judge, she's gonna, if the court's not inclined, and I can understand, if the court's not inclined to an ROR, then I just ask you to leave the bonds in place, and she will contact her parents to post her monetary bond.
I see no history, Judge.
Okay, so I'll leave the bonds in place. No alcohol or intoxicants, ma'am. Thank you. Good luck to you. Catherine Shannon, please.
Miss Shannon's approaching, and she advised me she has private counsel, Mr. Stephen Baker.
Morning.
Good morning. Does anybody have Mr. Baker's number, or have they spoken to him?
I have not. When they brought me back in, it was because of oh, excuse me.
So your attorney, does your attorney know you're here? Do you have his number?
No, ma'am. When they brought me in, I didn't have my phone or any of my contact information. I moved to Colorado, so I missed my court date, and that's why they brought me back in here today.
Is he out of Hallandale Beach?
I believe so. But he's on Hollywood, Hallandale.
I've got, is it STEV or STEPH?
STEVEN BAKER.
Hallandale's probably the best bet, Judge.
All right, do you have the number? I'll call.
I do. It's 954-455-1933.
You have reached Baker, Rec, and Associates.
Is that
We cannot
it?
take your call right now. However, your call is very important to us. Please leave your name, your number, and the time you called, and we will get back to you as soon as possible. Thank you very much. We look forward to helping you soon.
I have, this is Judge Malika from Magistrate Court in Broward County. You could call my office at 7835. I have a Catherine Shannon, Shannon. She's picked up on 2 cases, $500 bond each. She indicated that you represented her. If you could call us back. Message, have a seat. Let's see if he calls back, okay? Thank you. Okay, give me 1 moment. Okay, next person's going to be Emily Falvey.
She's here present, Judge.
Okay, good morning, Miss Falvey. You have DUI, alcohol, or drugs, first offense, $500 bond. DUI with damage to property or person of another, $1,000 bond. DUI, unlawful blood alcohol level above a .15. Let's see. $1,000 bond, so total is $2,500, and count 4, no bond required, leaving the scene of a crash for involving damage to property. The court does find probable cause. What say you, defense? $2,500 bond total.
Judge, I'm going to be asking for an RWAR or pre-trial release on her behalf. I'll see if the state has an objection before I proceed.
I do.
Judge, and speaking Ms. Falvey, she's 34 years old, been living in our community for the past 5 years. Right now, she's working for a produce company in the warehouse, and they export different produce products. She's been working for the same company for 2 years. She lives in Pompano Beach. Her and her roommate share an apartment, which they've rented for about 3 years. The total, I guess, rent of the apartment is approximately almost $900 per month. From what Ms. Falvey advised me, right now there's nobody she can contact to help post her monetary bond. That is why we're going to be asking for the court to consider releasing her with no monetary bond.
Your Honor, I'm going to be requesting a $5,000 bond on count 1, noting that this was first this was a crash case involving 2 other vehicles. Her breath results were .239. She's alleged to have left the scene of the crash. I would also note that it does appear she could be facing a felony upcharge, as I show she has 2 prior DUI convictions out of the state of New York, one in 2012, one in 2005. I do believe Ms. Falvey poses a danger to the community. I'd also ask, in addition to the bonds, that the court order that she be supervised by pretrial release services, that she be placed or fitted with a TAD monitor, No driving, no alcohol or intoxicants.
Judge, we wouldn't have an objection as far as with the TAD monitor and all the other conditions that the state has mentioned relating to pretrial release, but from what Ms. Falvey advised me, she really can't afford any sort of monetary bond. So, like I said, we wouldn't have an objection on her being supervised and with all the conditions that the state has requested.
What years did you say?
2012, 2005.
Those are convictions, right?
Yes, ma'am.
How are we doing on the TAD monitors, Ms. Patrice? All right, can we call them and find out? All right, so all right, we're going to pass this case. We're going to wait till we hear about the TAD monitor. No, I believe you. We're going to wait. Alexia Ruth.
No problem, John.
Okay, Miss Ruth, you have possession. Oh, sorry about that. Miss Ruth, you have possession of heroin, $1,000 bond. Possession of methamphetamine, $1,000 bond. Drug paraphernalia, possess and/or use, $100 bond. Total is $2,100. The court does find probable cause. What say you, State? Does she have priors?
No, Judge.
I was going to ask for pretrial release, Judge.
All right, court's going to ROR her. Thank you very much. Good luck to you, ma'am.
Thank you.
Lauren Phillips,
North Broward also.
North Broward.
She's a medical reset, John.
Thalia Fundoro Lopez. We need.
Judge, bonded.
Thank you. Court finds probable cause. Shirley Colas,
Yes.
North Broward.
North Broward.
Going to be asking for ROR pretrial release from Miss Colas.
All right, good morning, Ms. Colas. You have touch or strike battery, $1,000 bond. Count 2 is a felony resisting an officer obstructing with violence. We need to talk about bond. And count 3 is resisting an officer obstructing without violence. What say you, State? And if I could have a prior record.
Your Honor, I see no history. That being said, she had possession of cannabis in 2016, but that's really shouldn't have any weight on this. But that being said, I would object to outright pretrial release based on these allegations, noting that this incident was witnessed by 2 independent witnesses and was caught in surveillance. Noting, according to the allegations, she punched the victim in the face multiple times. She scratched his right eye area, stuck her finger in his mouth and began to pull, causing small abrasions to the inside of his mouth, causing him to bleed. And then she acted violently with law enforcement when they attempted to arrest her.
All right, what can she afford in bond?
Well, Judge, in light of the fact that she's lived in South Florida all of her life and has spent her entire life living with her parents and is currently studying to be a medical assistant, has no prior record, is a registered voter, I believe her mother could possibly afford maybe a $500 bond on count 2 if you leave count 1 where it is.
Anything further?
No, Judge.
No, Your Honor.
All right, court finds probable cause if I didn't say it, 1,000 on 1, 500 on 2. No victim contact, direct or indirect with ARC, and I want you to maintain 500 feet at all times. Do you understand?
Yeah.
All right, no possession of any firearms, ammunition, or weapons, and if you do have any, you're to surrender them within 24 hours of your release. Court's also going to put you on standard pretrial supervision. Deputy will give you a map, which means you have to report once a month in person. Call in twice a week. And the most important first step is to report within 24 hours of your release. Otherwise, there'll be a warrant issued for your arrest. Thank you, ma'am. Good luck to you.
And I'll call your mother after court.
Hold on one moment. Huh? Oh, 3? All right, so let's call back. Make sure you report within 24 hours, ma'am. Thank you.
Okay.
All right, main jail. Let's call Emily Hunter Favley back.
No problem. She's right back.
All right. So what can your client afford in bond?
Judge, Ms. Falvey has advised me nothing.
Does she have any family members or friends that can post $100 for a $1,000 bond?
I asked her as far as her roommate, and she advised me no.
If I could have access to my stuff, I could do $100, but.
Oh, it's in your property? Okay, then we can get a property order.
Okay. All right, she's gonna have to contact a bondsman. Can she get that information from in there?
I believe there are phone numbers, Judge, and it's just a matter of her contacting bondsman who's willing to come over here and, I guess, pick up, she would have to voucher out her property. I don't know which bondsman would be willing to do all that.
All right, well, she's gonna have to find somebody. So ROR on 1, 1,000 on 2, ROR on 3. I'm gonna order no alcohol or intoxicants, random testing at her expense. TAD monitor, standard pretrial supervision. Anything else, State?
Driving?
No driving until further order of court, ma'am. Thank you. Make sure you tell her, Mr. Romero, she has to pay the bond first.
Excuse me, Judge, before we get too far.
Sure.
I see they called Jordan Harris out of turn on the felony docket, the 93806. And on count 6, he's not on probation. I made a copy for you to show.
What is he on?
He's on probation, but they charged him with 6 counts.
Can I have the paperwork back, please? Thank you. Yeah?
And it's even noted at the top. That case, he only got a year.
Well, this is a disposition. There is not an active VOP on the case. Probation terminated.
Yeah, and that's on count 6 case number.
So there should be no count 6?
We can dismiss it, right? Or,
Okay, count 6 is dismissed. Does anybody know the private attorney, Bill Durango's number?
Okay, thank you so much.
Huh?
Find a way
Did he say it was Durango?
to. Lorenzo.
Durenzo?
Direnzo.
954.
2117.
Thank you, Keitha.
Hello, you've reached the law office of William Dorenzo. Sorry, I am unable to answer your call right now, but it is very important to me. If you could leave me your name and telephone number, I'll get back to you as soon as possible. Thanks for calling and have a great day.
Please leave your message after the tone. When done, hang up.
Hi, Mr. Dorenzo. Calling you back about Jordan Harris. You were just here in first appearance magistrate court. I just was advised by pretrial services, they weren't here when you came in the courtroom this morning. Anyway, I was advised that count 6 probation violation, I'm going to delete it from the docket and a finding of probable cause because it actually was terminated on April 4th, 2014. So he now just has 5 probation violations. Thank you very much. And that's case number 116878. CF 10A. Let me just double check that case number. 116678 CF 10A. I apologize. Thank you very much. Bye-bye. All right.
Oh. So.
All right, thank you. All right, so next one's going to be Isabel Viveros.
We're waiting for the Spanish interpreter, Your Honor.
Okay, who else do we need for the Spanish interpreter? I'll pull them now. And what page is that?
7.
7, okay. Okay, Mr. Romero, anybody else?
Judge, there is one person. His name is. It's Andres. I gotta find him. I wrote it down here somewhere. It's Mr. Andres Blanco. He is on page 14. However, Judge, he has private counsel, Mr. Lance Garrett. I did speak to Mr. Lance Garrett. He has, I believe, another case being addressed today at 1 o'clock. So he's asked to roll this case to 1 o'clock this afternoon.
Okay, so this is page what now, though?
14.
And this is Andres Eloy Blanco Palma?
Correct, Senor Blanco.
And I'm sorry, can you tell me his attorney's name again?
Lance Garrett. Mr. Garrett also has another hearing, I believe, with Mr. William Bell.
Oh, that's right, that's right. Okay.
So he's asked if he could roll him over to 1 o'clock.
Okay, if you could just tell him in Spanish, I'd appreciate it.
No problem.
All right, anybody else?
No one else right now.
All right, thank you. Any?
No,
just the one we're waiting on.
Who's the one you're waiting on?
Rose, on page 7. She's the one that needs suspension interpreter.
Oh, Isabel, okay.
Yes, yes.
Okay, I thought they were at Maine. I get it now, thanks. Conti?
No, ma'am.
Hi, how are you? Okay, Paul Ryan? Paul Ryan need a Spanish interpreter? Guess not. Okay, Daniela Gonzalez Restrepo.
She's here, present, Judge at Maine. She's approaching. Come on up, ma'am.
Hi. All right, good morning, Miss Restrepo. You have retail theft, $300+ coordinate with others. Bond set at $1,000. Court does find probable cause. Court's going to order no return to the Marshalls and TJ Maxx at 12801 West Sunrise Boulevard in Sunrise, Florida. What say you, Mr. Romero?
Judge, speaking, Ms. Gonzalez. My understanding, this is his first contact with the criminal justice system. We're going to be requesting an ROR, and I'll see if anyone has an objection, Judge.
Judge. Doesn't have anything? I have no objection, Your Honor.
What's her home address?
I'd like the judge to know your home address.
601 Northeast 23rd Street, Miami, Florida 33137, apartment 902.
Okay, it's 601 Northeast 23rd Street, Miami, Florida.
33137, apartment 902.
How long have you lived in Florida?
1 year.
Do you intend on remaining here?
Yes.
All right. Okay, per state and defense, ROR. All right, let's call Isabel Viveros, page 7. North Broward.
Yes.
All right, raise your right hand. Do you swear and or affirm to translate from English to Spanish, Spanish to English to the best of your ability?
I do. Esteban Rojas.
Okay, thank you, Mr. Rojas. Page 7. Ms. Viveros, you have retail theft, $300+ coordinate with others.
Señora Viveros, usted está acusada de cometer hurto en un establecimiento comercial por un monto de $300, $300 or more, Your Honor?
$300+ coordinate
por
with
un monto
others.
de más de $300 en coordinación con otros.
$1,000 bond.
$1,000 de fianza.
Court's going to order no return to Marshalls and TJ Maxx.
Se le ordena no regresar a Marshalls y TJ Maxx.
Located at 12801.
El almacén localizado en la 12801.
West Sunrise Boulevard.
West Sunrise Boulevard.
Sunrise, Florida.
En Sunrise, Florida.
If you go back to the TJ Maxx or Marshalls, ma'am, you'll be arrested.
Si usted regresa a esos locales de TJ Maxx o Marshalls, señora, será arrestada.
Court finds probable cause.
La Corte considera que existen indicios probables de delito.
What say you, defense?
¿Qué dice la defensa?
Well, we tried to talk, Judge. And Ms. Viveros does speak a little English, but we really weren't able to make a lot of progress.
Intentamos hablar, señora juez. La señora Vivero sí habla un poco de inglés, pero no pudimos avanzar mucho.
All right, so why don't you speak to her because we have to do that out-of-state hold with confinement.
Bueno,
issue.
hable con ella porque tenemos
Because I
que
would
hacer
like to
otro
find out her ties
trámite
to the
de
community.
extradición.
If she has no prior record,
Quiero indagar sobre sus lazos con la
I'd ask you
comunidad.
to-
Si la señora no tiene antecedentes,
I'd ask you to ROR her as you just did the co-defendant.
solicitaría que la liberara bajo palabra de la misma forma en la que lo acaba de hacer con el coacusado o coacusada.
How long have you lived in Florida, ma'am?
¿Cuánto tiempo tiene usted de vivir en Florida, señora?
This year.
Conteste en español.
8 meses, 6 meses.
8 months, 6 months.
Where are you from?
¿De dónde es usted?
Colombia.
Colombia.
Yo estoy estudiando inglés.
I'm studying English.
How long do you intend on staying here?
¿Cuánto tiempo piensa quedarse acá?
Bueno, 3, 4 meses termino ya mis niveles.
In 3 or 4 months, I'll finish my coursework.
Okay, and then you're going to go back to Colombia?
Aproximadamente.
Y luego regresa a Colombia.
Yeah.
Yes.
All right.
Fine with an R1.
Okay, per the state and defense, ROR.
Thank you, Judge.
Bien, la Fiscalía no tiene objeción. Excarcelada bajo palabra.
What is your mailing address, ma'am?
¿Cuál es su dirección postal, señora?
Come on, Michelle. Don't say that.
2200 Northeast
2200
4th Avenue.
2200 Northeast. ¿Northeast qué?
4th
No,
Avenue,
East 4th,
4th Avenue.
402,
402.
402.
402.
All right, thank you. The court finds probable cause.
Bien, gracias. La Corte considera que existen indicios probables.
All right, we have no others. Thank you.
No others. Okay. Pleasure.
This one, Steve Baker, call him again. All right, let's call Ryan Barney back. Recall. North Broward.
Yes, no problem.
All right, Sheila. He's saying, welcome back, sir. All right, we have confinement status
How are
here
you?
now. Fine, thanks. So you were saying that, and don't talk about the facts of your case or anything. You're
No, it's, no problem. I'm here. I study at Penn State University for marine biology, and I came down to work for a company down here to study with the red algae problem that's going on down here. And I guess they assumed that I was my brother, and they just picked me up. Like, I have no ad charge. I've never been arrested in my life. Like, so I'm just.
It doesn't even say how he got picked up on here.
My apologies for
No.
Honestly, Your Honor, he was picked up on a warrant. I mean, out-of-state warrant. I don't have any information.
Yeah,
Well, normally,
they just thought I
hold
was
on,
him.
sir. Normally it says he's at the airport or something like that. So that's what I'm trying to say. I'm trying to figure it out. I don't want someone wrongfully detained. So Sheila, what say you, confinement status?
Well, there's a hit confirmation from Pennsylvania with his name, date of birth, and so far they're confirming that it's him and they're gonna pick him up. So
All right, so suppose it's not him. I know there's something that says, but suppose it's not him.
well, that have to be verified from the other state. You can ask the other state, who they have. But right now, the hit is coming back to him.
What's your date of birth, sir?
5/14/97.
At the time of booking, he told them the date of birth was January 24th.
No, that's not true. The police told them that.
Because when they did booking him, they re-asked them all of the same questions. Their name, their date of birth, and that's the date of birth that he gave them at booking.
He's been arrested.
1/24/94.
He's been arrested, from what I can tell. He's been arrested twice on this out-of-state hold. I don't know if it was the same one.
It should go by the OCA number, because it shows what OCA number.
What is OPA? Sheila.
When they come in from out of state, it's either
The first time
NIC number, which is the
you don't
warrant
read his
number.
picture.
Okay.
It's the same BCCN
OCA
number.
will always be that.
He filed a waiver.
All right, what are you saying, State?
I guess I'm just a little confused because I could have sworn he said he's never been arrested before.
He did.
My brother has.
He has been arrested on December 30th of last year.
That wasn't. I just came down.
It's his BCCN number. It's based on his fingerprints. So he was arrested December 30th of last year on charges. I'm sorry?
Do you have a pic?
I do, Your Honor, but frankly, I mean, it's his, even if it doesn't, you don't think, that clearly is him, but that's why I mentioned it. It's the same BCCN. It doesn't matter. It's the fingerprints. It's the same BCCN number each time. So it's based on his fingerprints. He was arrested at that time on 2 counts of aggravated assault and an armed burglary. The charges ended up being no info and an out-of-state hold. He was also arrested October 23rd of last year on another out-of-state hold. And I just find it confusing that he's telling the court he's never been arrested when this is the 3rd time since November of 2017 that he's been arrested in Broward County alone.
What I meant, sir, is I've never been convicted. I have nothing on my record. I've never been convicted of anything. That was a domestic dispute that was settled within 20 days of me. Like it was. I don't have anything on my record. I'm going to school. I'm really trying to.
Well, I don't know what he means. I just know what he said, and he said he's never been arrested.
All right, I'm gonna find probable cause, however, Sheila, how do we do this? I just wanna make sure, I don't want someone innocent in jail if it is his brother. How do we do a request that he's saying it's a not me case?
Then we're gonna contact Pennsylvania and ask Pennsylvania to send us either ID number, photo, or print.
Well, on its face, but this has gotta be looked into, so I'm gonna put.
Well, they'll do that. They'll do that.
So you're gonna request it today?
Yeah, I have a book today.
Okay. Thank you. All right, make a copy of this, and then maybe you can get back to me in a day or two and let me know. Thank you, Sheila. All right, sir. I'm gonna find probable cause. You're gonna be held no bond. We have extradition court on Tuesday or Thursday. They're gonna examine your prints and your photos from Pennsylvania. They're gonna request them today, okay? And they send them, obviously, teletype or whatever.
We communicate with teletype and they'll fax over.
Okay. All right, thank you, sir. Good luck to you. Shanika Jones.
Ms. Jones is here present, Judge on Main. She's approaching.
Morning, Miss Jones. You have possession of MDMA, ecstasy. Court does find probable cause. $1,000 bond. Does she have any prior state?
She does, but they're dated. And she has 3 prior failures to appear.
All right, I'll put her on standard pretrial.
Yes, Judge.
Unless she wants to pay the bond.
No, we would be asking for a pretrial release.
All right, 24 hours of release. She's got a report. Call in twice a week, report once a month. Thank you. No reporting after court. Janae Rowe. Yes, Miss Patrice? So the regular, but no after court.
Come on up, please.
Morning, are you Janae Rowe? All right, you have grand theft between $300 and $5,000. You could stop tapping your fingers, I'd appreciate it. Court's gonna order no return to the target at 3599 West Hillsborough Boulevard, Deerfield Beach, Florida. If you go back there, you will be arrested. Do you understand?
Yeah.
All right, $1,000 bond, court finds probable cause. What say you, Mr. Romero?
Judge, my understanding is this is her first arrest. If the state can confirm that, we're going to be asking ROR.
I have no objection.
Okay, per state and defense, ROR. Thank you.
Thank you, Judge.
All right, we never heard back from Mr. Stephen Baker. So should we just reset it for 1 p.m. or should we, does she want to be represented by the public defender for purposes of today?
Judge, he's here, but my understanding, he's actually filed a notice of appearance.
He has?
No notice of appearance has been filed in this case.
Where did you get the idea that, where did you get that from?
Oh, no, not officially on this one, but we were actually supposed to meet today to talk about it, actually.
All right, well, he's not available, so you're gonna have to either represent yourself or fill out an application for the public defender, and you can do it after the hearing today. Okay?
Okay.
All right, so you have 2 capious misdemeanors for trespass in structure or conveyance, trespass property, other structure, $500 bond on each. What's your mailing address, ma'am?
Oh, it's 1078. It's on Thomas Street now, but I live in Colorado, but I'm home doing a move. So
Just to let you know, count one, I looked at the information. Count one's actually disorderly conduct.
Okay, it says on the booking, on the capias. So disorderly conduct.
Yes.
Are you showing that, Madam Clerk? Huh?
I know that's what, I pulled the information, it's disorderly conduct.
All right, well, that's an error in the machine, so it's gotta be corrected.
But Judge, for magistrate, if you can, don't take out the trespassing, because that's what she put.
Well, everybody's gonna have to work it out because I'm not having her if she's gonna resolve it. I'm finding count one is the capias is for disorderly conduct. So they're gonna have to change it, the clerk's gonna have to change it.
The clerk has to change it, but as far as like, don't scratch out the trespassing, just do how you want with your final copy.
I put disorderly conduct, I'm not putting it for something it's not, Sheila. I didn't cross out anything, I just wrote in disorderly conduct. So you feel better, okay? All right. Does she?
Okay, I'll take care of
And Judge, speaking with Shannon, she does wish to resolve this matter today.
All right, let's pull these cases.
No problem.
It's case number 18-9124 MM10A. Thank you, Eric. It says right here, disorderly conduct, trespass on property other than structure. It is a change of charge, it does say. So I'm gonna clerk to update forthwith count one to disorderly conduct. What's your, what's your offer state?
It'd be a withhold court cost on both counts. No return to 530 Southeast 4th Court in Dania Beach.
Judge, having heard the state's offer, Ms. Shannon wishes to accept the state's offer, Judge.
All right, what's her updated address?
1078.
Is this for Colorado or here?
Oh, well, I'll give you Colorado, the location it was here. Colorado.
Because this is the thing, I'm gonna do a withhold of adjudication but court costs of $293. And you're gonna have to pay them within 6 months. If not, they're gonna send word to Colorado and Florida as well that you haven't paid the money and they're gonna suspend your driver's license, then you're gonna get arrested. If you're driving while your license is suspended, $25 late fee, and it's gonna affect your credit. So you can make partial payments. So which address do you wanna give where you're gonna get your notices at?
I prefer the 279 Southwest 8th Street in Dania. That's a family household.
279
Southwest 8th Street in Dania. 33004.
Is it Dania or Dania Beach?
Dania.
All right, does your client want to resolve the cases today for a withhold and court costs?
She does, Judge.
All right, how does she want to plead to them?
No contest.
All right, withhold on count one and court costs of $293, 6 months to pay, partial payments accepted. That's the disorderly conduct, the trespass property of or structure, withhold of adjudication. The court takes judicial notice of time served in the Broward County Jail. I'm going to direct the clerk to update forthwith count one to disorderly conduct. And I'm also going to direct the clerk to change the defendant's address to 279 Southwest 8th Street, Dania Beach. Thank you, ma'am. Good luck to you.
Thank you so much.
Okay, and ma'am, I'm going to give you this as well. Jessica Lopez Gomez.
Andrew Coffey is Miss Lopez Gomez's attorney, Your Honor. He's on his way.
Tony Sherrard is an MO case. Call up Mr. Shade, tell him we need him here. Ryan Power.
Excuse me, Your Honor. Your Honor, Conti.
Yes.
Tony Sherrod is in courtroom 6810 this morning.
It's the MO, Judge.
Well, it might not be. I don't think it's assigned yet.
He has a no bond hold on count 2 for a capias.
All
That
right,
might be why he's there.
Virginia, you're going to have to call up downstairs. Hold on one moment. It is Virginia. Ryan Scott Power.
Yes, Mr. Power's here.
Main jail. Good morning, Mr. Power. You have 2 capias misdemeanors, $500 bond to each. It is for driving while license is suspended and suspended driver's license, first offense. You no-showed at a non-jury trial before Judge, Evans? Judge Cal Evans. Two times on October 9th and both October 9th. So you're going to see Judge Evans tomorrow at 8:30 a.m. Thank you, sir. Good luck to you.
Judge, Mr. Power advised me to ask the court if you would consider resolving this matter today.
I'm showing a DWS in 2017. If he resolves these charges, it could very well result in a 5-year suspension.
I did advise
Do we
him
have
that
his driving record on Ryan Scott Power? Thank you. It is going to be his third.
I did advise him of that, Judge. I did advise him the consequence that basically DMV would now probably label him a habitual traffic offender, and if he caught driving, it's going to be a felony. And he's aware of that, Judge. He still wishes for me to ask the court if you would consider resolving it.
I'm not going to resolve it. Let him go before Judge Evans tomorrow. Thank you, sir. Good luck to you. Okay, next one is an MO case. So we have David Adam Ortiz.
Mr. Ortiz, come on up. And Judge, Mr. Ortiz advised me he has a private attorney, Mr. Philip Mendito. Good morning, Judge.
Good morning. Can anybody speak to Mr. Mendito? What's your attorney's number, sir?
It's in my cell phone, ma'am.
How do you spell his last name?
I'm not entirely sure. Yeah.
641.
What is it? 641. What is it? Do we have any other private attorneys? I want to pull them all now out of a stack.
Let me look through my list, Judge. Yes, on page 14, Mr. John Jones, Ron Baum.
Hold on, let me get to the thing. John Jones.
Johnny Allen.
What page? 14?
14, Mr. Ron Baum.
Did anybody speak to him?
I left him a message earlier.
What's his number?
954-849-0149.
Okay, anybody else?
Now, as far as I got up to page 20 interviewing, so let me make an announcement, Judge, to see if anyone on page 20 and on has a private attorney.
Thank
Anyone
you.
that I haven't spoken to have a private attorney that we need to contact? Yes, one person. Anyone else that has a private attorney? Michael Wentz. Okay. Judge, two people. What's your name, sir? Troy McLeod. And who's your attorney? Who? Bob Nicholson. Do you have his phone number, sir?
I have it.
Okay, so Mr. McLeod.
He's the last case on your docket,
Who's
Judge.
the, you said Jones?
No, Troy McLeod. The last case on your docket.
Okay, that's easy.
So Bob Nichols.
Okay, wait, Troy McLeod is private attorney who?
Bob Nichols.
Robert Nichols.
954-779.
Okay.
3313.
I'm sorry, that's page what?
Page 23.
Okay, page 23. And who's the next one?
Mr. Elliot Glasser, Judge.
Where is he?
He is on page, I'm trying to find this page right now, but he has Andrew Coffey.
And you said he's on his way, right? Mr. Reading? Mr. Reading? No. I'm sorry, in what page?
I'm still trying to locate Mr. Glasser.
He's page 20.
Okay.
Page 21, Hector.
Oh, 21, I'm sorry.
Okay, private Glasser. And there was one more that just raised his hand, Judge. Let me get his name. What was your name, sir?
It's Mr. Joseph, he's got Weinstein.
What's your first name? Jermaine Joseph, Judge. He has Mr. Michael Weinstein, and he is on page 22 of the docket.
So Joseph. Page 22. We have his number?
Do you know his phone number, sir, or no? No? No, Judge, I'm sure.
Do you have it,
Probably
Mr.
listed on
Linder?
the Florida Bar website.
All right.
Anybody else have private attorney? Anybody else? No, okay.
All right. You're Mr. Philip Mendito? I'm sorry, David Ortiz?
David Ortiz, yeah.
Yes.
Good morning, office.
Yes, hi, this is Judge Malika. You're on speakerphone. You're being recorded. I'm in Magistrate Court in Broward. Is there an attorney, Philip Mendito, there?
He's actually in court right now, and I'm sorry, there's a lot of static.
All right, Mr. Ortiz, do me a favor. Hit the mute button at the main jail. All right, I'm sorry about that, ma'am. Okay, it is regarding, does he have a client, David Adam Ortiz?
David Ortiz? Yes.
All right, he's actually in first appearance court. Is there any way you can contact Mr. Mendito and tell him that his client's in magistrate court, or do you want to give me his cell and I could try that too?
Your Honor?
Yes, I will contact him and I'm giving you his cell phone number as well.
Your Honor.
It's 954-854-5213.
Mr. Mendito withdrew on this case.
He did?
July of this year. It was granted by Judge Zeller.
We were hired again for a motion to withdraw habeas. We've been trying to get in contact with the assistant state attorney. So he paid us to retain his services for the motion, but we just haven't gotten the unopposed to go ahead and go forward with it, from my understanding.
All right, so why don't you do this? Why don't you tell Mr. Mendito that I have Mr. Ortiz here. He can appear by phone. Why don't you text him, then I'm going to call him in a minute, okay?
Okay, and what's the judge's name again?
Mollica, Mollica.
Thank you, will do.
And it's courtroom 4155, the new courthouse.
4155, got it, thank you.
All right, we'll call you back and see what he says if we can't get a hold of him. Thank you.
You got it, thanks, bye.
Bye.
Hello, you've reached the cell phone of Attorney Philip Mendino. I can't get to the phone.
Okay. All right, we'll recall for your attorney in a moment.
That's what I want to see.
Let's get John Jones up, page 14.
Mr. Jones, come on up, sir.
Regrettably, I'm not available to take your call at this time. If you leave me your name and number, I will be sure to get back to you at the first opportunity I have. Thank you.
At the tone, please record your message. When you've finished recording, you may hang up or press 1 for more options.
Hi, Mr. Baum. This is Judge Mollica calling you from First Appearance Magistrate Court in Broward. I have a person that says that you represent them by the name of John Bradley Jones. I am going to reset this for 1 p.m. today. So if you could come to the new part of the courthouse, 201 Southeast 6th Street. It's WW4155. If you have any questions, you can give my office a call, or actually you can call the public defender, 954-831. 6172. Thank you, sir. Good luck. Good luck. Listen to me. Okay. All right. So, Mr. Jones, we're going to reset you for 1 p.m. today, okay? Hopefully we can get in touch with your attorney. Thank you.
Okay, thank you.
Okay, Attorney Coffey is on his way, and Michael Weinstein. Can we have Jermaine Joseph, page 22?
Good morning, Your Honor.
Good morning. Wait a moment. I'm trying to get a hold of Mr. Weinstein. Does he know you're here? I can't hear you. You muted yourself. Does Mr. Weinstein know you're here?
No, you don't.
Hello, thank you for calling the law certified criminal trial attorney Michael T. Weinstein. If you've reached this message during normal business hours, please do not hang up and call again. Please leave a detailed message after the tone, and I will be sure to get back to you as soon as possible. If you have reached this message after hours, please do not hang up and call again. It means that I am either away from my phone or in court. Therefore, again, please leave a detailed message, and I will call you back as soon as possible. Thank you, and have a good day.
At the tone, please record your message. When you have finished recording, you may hang up or press 1 for more options.
Hi, Michael Weinstein. I am calling from Magistrate Court, Kim Mollica. I have a Jermaine Joseph in front of me. He's on page 22 of our docket this morning. He says that you represent him. If you could give the public defender a call and let us know, we can either have you appear by phone, you can come over to the courtroom 4155, or we can reset him for 1 p.m. Call Mr. Reedy, 831-6172. Thank you. All right, so we'll hold off on yours.
No, I was actually just trying to get a bond reduction of ROR. I didn't really need him here. That's just my attorney that represents me on every case.
All right, well, you can go forward today with the, I just called him, so why don't we wait a moment, okay? Have a seat. And then we have Robert Nichols. It's Troy McLeod, page 23. Yes, hi, you're on speakerphone. This is Judge Malika. You're being recorded. I'm calling you from First Appearance Magistrate Court in Broward. I'm being told that Mr. Nichols represents Troy McLeod.
Yes, ma'am.
All right, is Mr. Nichols available?
Yes, he just walked in. Just
Okay.
a moment, Judge.
Thank you.
Good morning, Bob Nichols.
Hi, Bob Nichols. It's Judge Malika. How are you? You're on speakerphone. You're being recorded.
Good, how are you?
Good. I have Troy McLeod in front of me that's here for magistrate court for a change of charge. It's for attempted first-degree murder.
Okay.
Do you
Sorry, I
represent
didn't
him?
get any notice of it. I got notice that they had filed, but not that he was coming up.
All right, so initially we held him no bond. Do you want to come down to the courthouse? Do you want to appear by phone? What would you like to do?
I'll appear by phone, Judge.
Okay. All right, can you hear your attorney, sir? Mr. McLeod?
Yes, I can hear you, Your Honor.
All right, thank you. All right, so sir, you have a change of charge for attempted murder in the first degree. Court finds probable cause. What say you, State?
Your Honor, I provided the court with a copy of your original findings at his first appearance. Your Honor, found proof evident or presumption grade for attempted first-degree murder. That is the charge we ended up filing, so I'd ask that you reimpose your original findings and hold him no bond.
Okay. What say you, Mr. Nichols?
Judge, I believe this, I understand that you made the finding originally, but I believe due to the nature of what my understanding of the injuries are, that this has been grossly overcharged. As I understand it, the victim was shot in the leg, allegedly from close range. At that range, had he wanted to kill him, would have shot him in the chest or the face, anywhere but the leg. But my understanding is he was shot in the leg, which is an aggravated battery. Based on the case being overcharged, I think he's entitled to a bond.
I don't believe he's entitled to a bond because Mr. Nichols believes the case is overcharged. Your Honor reviewed the facts originally. You made a finding of proof evident or presumption grade for attempted murder. That's what he's been charged with.
All right, well, hold on, Mr. Nichols. I'm going to print it out. I wasn't given a copy of the PC, so
Okay.
just want to refresh my memory.
Sure.
This is the case, Your Honor, where he chased the alleged victim into the barber shop, opened fire, shot multiple times. Looks like the victim was shot as he was running away, and he was being chased, which also would affect his aim. Sorry, yes, no, I'm sorry, this is actually at a laundromat.
All right, it says in here, Mr. Nichols, I reviewed video surveillance of the laundromat, which captured the incident that occurred in the parking lot. The video shows Hass and McLeod walking towards the parking lot. Hass then sits down on a light pole, at which time McLeod looks around and removes a firearm. He stands up and shoots at him. And then Hass begins to run away, and McLeod shoots at him again.
The PT also says, Judge, that he shot him from what appears to be fairly close range and shot him in the groin. Shot him in the leg.
Your Honor, I would also note that he shot more than once, which I would argue can be evidence of his intent.
All right, I am, unless I hear something more, I am going to keep my original ruling and make a finding of proof evident presumption great as to the attempted murder, first degree, and he can be held no bond until further order of the court. It would be without prejudice to file a motion to set bond with the assigned division judge and request a hearing under State v. Arthur. So is there anything else, Mr. Nichols?
No, Judge, we'll file our motion with the judge.
All right, thank you so much. Have a good day. Bye-bye. All right. Thank you, sir. Yes, hi. Can I speak to Mr. Nichols again? I forgot to tell him something.
Yes, just a moment.
Morning, Bob Nichols.
Hi, it's Judge Malika again. So I didn't tell you, he's going before Judge McCarthy. It says 12/17 at 8:30.
Oh, okay, great.
All right, just so you can put it on your calendar. I didn't know if you'd know it because the clerk did it this morning.
Okay, I appreciate it.
You're welcome. Bye-bye.
Bye.
All right. Did you hear back from anybody?
Yes, Judge, I spoke with Mr. Baum on John Jones.
Hold on, let me get the paperwork. What's Mr. Jones's first name?
John.
John Jones. All right, hold on. What page is he on again? 14.
Page 14.
Okay, and what did he say?
He does not represent Mr. Jones.
I have a William Jones. What is this one? Where did the paperwork?
You may have pulled it out of your stack because you called Mr. Baum.
What? Oh, afternoon. So then, can I have Mr. Jones?
Oh, has he already been reset?
Yes.
Oh, all right. Okay. Well, Mr. Baum will not be here, but
All right, so let's go forward. Where's Mr., is he still there, Mr. Jones? Well, let's find out. Mr. Romero, John Jones?
Mr. Jones. Mr. Jones, come on.
No, the wrong Jones.
Ron Jones.
John.
Oh, John Jones.
John. There are a couple Jones on the docket.
Okay, back.
All right, Mr. Jones, I've been advised that Mr. Baum is not representing you. He advised Mr. Reedy, the public defender, so let's go forward with your charge. You have...
We'd waive formal reading.
All right. Court finds probable cause. I didn't see the initials for a victim in here.
Yes, Judge.
Didn't see an age either.
Well, let me put it this way. If she's under 12, it's a punishable by life offense.
Yeah, but it doesn't say she is, and it doesn't seem like she is.
She's got to have some age. Your Honor, I was preparing to proceed that she's over 18 based on my conversation with the detective.
Okay.
Which makes it a first-degree felony.
Okay, that's fine. We can
I figured
because it's not what it says on the docket. So.
All right, so this is PC 4. What goes after the three first words?
Yeah, if we could put it on recall, because what's on the booking isn't necessarily the same as what's on the arrest sheet. So I just want to contact the detective.
All right, we're gonna recall. Have a seat.
It'll just be a minute.
Wayne Martin.
Morning, Judge.
Morning.
Mr. Martin is he's in the main jail. Wayne Martin?
Are you doing Oakland Park?
Yes, Judge.
So count 2 for the capias, not for count 1.
Yes, Judge.
All right, so Mr. Wayne Martin, you have commercial use of a straightaway, $25 bond. Count 2 is a capias misdemeanor for an open container. Let's wait for Mr. Lindsay.
Okay, no problem. I figured she was over 18. Okay, thanks.
You already appointed on the capias one?
In Mr. Martin's case, no, Judge, I have not been appointed.
Okay, State, I know that you were on the phone.
Yeah, no. The offer on count 1 would be adjudication, time served, no return to this location.
All right, I'm not gonna accept that, and I'll tell you why.
Okay.
He walks around, he says, please help us, U.S. Marine. He's been told by this deputy dozens and dozens of times.
I understand, Judge.
So, he keeps returning. He's been told to stop misrepresenting himself as a U.S. veteran because he's not a veteran.
And frankly,
And I remember this, and I want to pull up his last case.
And I do too, Your Honor, now that you mention it.
Judge, are we talking about Wayne Martin?
Yes.
Yes. So,
I
hold
have
on, let me just tell him. So I told, the commercial use of state right-of-way is $25. The capias misdemeanor for the open container of alcoholic beverages, $50 bond. I don't have a problem with resolving your MO case.
I can advise the court. I pulled the probable cause affidavit from his last state charge, 18-2787.
What is it,
2787, MM10A, unlawful commercial use, same charge. And it's the same allegation that has a cardboard sign which read United States Marine, please help. It mentions he's not a veteran of any U.S. military branch. He was given 3 days county jail on that case. And then I pulled the PC from a 2016 trespass. Same situation, United States Marine, please help, even though he's not a veteran.
I mean, he just has such disregard for the court's order, so.
He was actually charged in 2015. Well, he was arrested, I'm sorry. He was arrested in 2015 for soliciting and misrepresenting as a member of the military. The charge was declined.
He's been offered to be taken to local shelters and given an extensive list of free places to eat every day. He's a habitual solicitor and endangers himself and the driving motorist each time he stands in the middle of the roadway. So, I'm not going to resolve it. What say you, defense?
Judge, I can only speak for him on the open container.
No, I'm asking Mr. Reedy or
Oh,
Mr.
okay.
Romero. Mr. Reedy? You have him on
I
count
think
one.
Mr. Romero may have spoken to you.
On count one.
Judge, he wishes to resolve this state offense as well, Judge.
What's your
Yeah,
offer?
Your Honor,
I don't think he heard the conversation.
and I do apologize. I
something
didn't,
else.
in full candor, I did not see the part about the
I understand.
military, and I do consider that to be, while that's not what he's charged with, I do consider that to be an aggravating factor that the court should take into consideration in sentencing, based on the fact that earlier this year he was sentenced to 3 days and just multiple examples of doing the same exact conduct. I'd be the offer would be 10 days, Your Honor.
Judge, respectfully, he's going to be declining the state's offer of 10 days. The $25 bond is going to be hard on him. He's basically, from what he advised me, he's homeless. Yes. He's 100% disabled. There's, from my understanding, no one that could place his monetary bond. Would the court consider releasing him or on pretrial?
No, I'm going to raise his bond, as a matter of fact. So, inclined to raise it to $1,000.
Well, $25 to $1,000, he's not going to be able to afford the $25, so.
Well.
That's even more of an amount he can't afford, Judge.
Okay. All right. And I'll tell you what, on the capious misdemeanor, I'll do an adjudication time served if he wants to resolve the case.
Yes, Your Honor.
All right. Raise your right hand. Do you swear and or affirm to tell the truth?
Yes, ma'am.
All right. Put your hand down. Is your name Wayne Henry Martin, M-A-R-T-I-N?
Yes, ma'am.
All right. It's my understanding through your attorney, Mr. McLaurin, you want to resolve your open container case today?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication?
No alcohol, no, ma'am. They gave me something.
Are you under the influence of anything, sir, that affects your ability to understand what's going on here today?
No, ma'am.
One moment. All right, how do you want to plead to open container? Beverage violation, guilty, not guilty, no contest.
No contest.
You understand that you feel that pleading no contest is in your best interest?
Yes, ma'am.
All right, adjudication time served, $78 in court costs. Court's going to find his plea freely and voluntarily entered after review of the court file. 6 months to pay, partial payments accepted. That's on case number 181595 MO20A. $1,000 bond on 1. No return, sir, to 3101 North Federal Highway.
Yes, ma'am.
Judge,
Can I finish? Hold on. Oakland Park, Florida. Thank you, I appreciate it. Oakland Park, Florida. And I want you to maintain a minimum of 500 feet from that address. Yes, Mr. Romero.
Judge, in speaking Mr. Martin, he wishes me to ask the court if the court would consider getting involved in extending out for adjudication 5 days.
No, 10 days, Broward County Jail. I mean, he's been habitual, he's a habitual offender. He's been
No
told
further
not to go back there.
questions, Judge.
Okay, that's fine. I'm also gonna put him on standard pretrial supervision. He's got to report within 24 hours of release. And I want him calling in twice a week. He doesn't have to report during the month except for the first time, and no reporting after court. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you, sir. Good luck to you. Okay. All right, next one, Arthur Lee Mitchell, please.
He's in the main jail as well, Judge. Arthur Mitchell. He's coming up. He's all the way in the back.
All right, good morning, Mr. Mitchell.
Good morning. How you, Your Honor?
I'm fine, sir. You have a municipal ordinance violation. It's an alcoholic beverage violation. You also have a trespass after warning charge. One, you're going to be represented by the public defender, which is the trespass charge. And the alcoholic beverage violation, you're going to be represented by Mr. McLawrence. Where is Mr. Romero?
I am here, Judge. I didn't know if you wanted me or not here.
Yeah, because you're going to represent him on the...
Ordinance on count one.
Count one is a municipal ordinance.
Oh,
Judge.
that's right. I'm sorry, my bad. So the trespass. Thank you, Mr. Romero. Sorry about that. All right, so sir, you have two municipal ordinance violations, $25 bond, $100 bond. One's for trespass and one's for an alcoholic beverage violation. Court's going to appoint Mr. McLawrence on both of them. What say you, Mr. McLawrence?
Judge, with regards to the trespass, just so the court understands, in speaking to Mr. Mitchell, he explained to me that this was his attempt at trying to get some help for him to get arrested on the trespass. That being said, he wants to resolve both cases, Judge. We could either send this case to Judge Wren to see if she might be able to help him. Alternatively, I did explain to him about the Henderson CRC, and he told me that he's interested, very much interested in participating in that to see if they could help him with housing. So we could also resolve it that way, Judge.
Well, if he's going to go to Judge Wren and you're even mentioning that, then why don't we let him go to Judge Wren? He sounds like he needs the assistance, and I'd rather see someone, you know, not be a repeat offender and set someone up for failure.
That's fair, Judge.
Okay?
Yes.
So on both these cases, we're going to do a referral to Judge Wren and ask her to set this. It does say it has a status MM tomorrow at 9 a.m. So now we're going to transfer them to Judge Wren. So just make sure there's not a warrant issued there, you know.
Okay, I will.
Because I don't know if the clerk will have the paperwork in time. So I'll do in these two charges.
Sign on the yellow line.
You don't need to write it down, just take it.
So, Mr. Mitchell, you're gonna stay in detox until you go to Judge Wren's division, and we'll try and help you from there.
Okay.
Thank you, sir. Good luck to you. Hold on, we're going to go off the record first.
He's in the main jail, Judge. He's on page 11 of the docket.
Okay, page 11, main jail. All right. Okay, Mr. Bennett, you have two capious misdemeanors. They're actually MO cases, possession of controlled substance and possession of paraphernalia. Says no show arraignment, count 1, bond $25, December 3rd, 2018. Does he want to resolve them?
He does, Judge.
Withhold and court costs on each case.
Thank you, Judge.
$78. 10318, 10364, MO 10A, and 10364, so they're both the same case number.
Yes.
So, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Press that button in front of you. Yes.
Yes, ma'am.
All right, thank you, sir. Put your hand down. What's your name?
Johnny Bennett.
Cornelius Bennett.
Yes, ma'am.
Bennett.
Yes, ma'am.
All right, your attorney, Mr. McLawrence, has indicated that you want to resolve your case today and give up all your rights to a trial.
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
How do you want to plead to possession of controlled substance and possession of paraphernalia? Guilty, not guilty, no contest.
No contest.
You feel that your no contest plea is in your best interest?
Yes, ma'am.
Ever been treated for a mental illness?
No, ma'am.
You doing this freely and voluntarily?
Yes, ma'am.
All right, the court's going to accept your plea, find that it's freely and voluntarily entered. Court has reviewed the court file, finds probable cause for the plea, withhold of adjudication. On each count, court costs on count 1 of $78, 6 months to pay, partial payments accepted. Court takes judicial notice of time served in the Broward County Jail. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you. Good luck to you, sir.
All right, thank you.
Just
Okay, who else
one
do
last
we
one,
have?
Judge. There's Rudolph Lazo.
Okay,
He's
where's
on
he?
he's on page 9 of the docket, Judge.
Thank you. Where is he? Rudolph Lazo?
He's in the main jail. It's coming up. Judge, may I approach for one moment?
Absolutely.
This is the PC for that case.
18.
I bring it to the court's attention because it's another open container, and Mr. Lazo wanted to see if he could take advantage of the Henderson CRC.
Okay, so today, sir, we're here today on a capious misdemeanor in 95459 MO 10A.
And that's actually a misprint by the whoever printed the docket, Judge. It's supposed to be 18.
9549, I see it.
Yes.
All right. Sheila, did you hear that with the case number on the booking sheet? It's wrong.
Rudolph, yeah, it's on page 9.
It says 95459. It's just 9549. I crossed it out with one line, wrote it in. Okay, so you want to resolve also 1810355 MO 10A?
Yes, Judge.
All right, so sir, you want to raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, Your Honor.
All right, put your hand down. Is your name Rudolph Lazo?
Yes, Your Honor.
You want to resolve your 2 open container cases today?
Yes, Your Honor.
All right, how do you want to plead to them? Guilty, not guilty, no contest.
No contest.
And you're giving up all your rights to a trial?
Yes, Your Honor.
You've had enough of time to talk to Mr. McLawrence?
Yes, I did have time.
Right, you feel that no contest is in your best interest?
Yes, Your Honor.
All right. So, no contest plea, withhold on each one. Court costs $78 and court costs on each separate case. 6 months to pay, partial payments accepted. Court takes judicial notice of time served in the Broward County Jail. I'm going to find his plea is freely and voluntarily made. Find probable cause. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you, sir. Good luck to you. I signed your orders appointing you, Mr. McLawrence.
Thank you, Your Honor.
All right. So he'll go there 9 p.m. tonight. Thank you.
Thank you, Judge.
Come on up.
Hi, Judge. Good morning.
Hi, who do you have?
Page 9 of Your Honor's docket, David Ortiz.
Who?
Page 9, David Ortiz, Judge.
All right. How you doing, Mr. Mendito?
Good, Judge. How you doing?
Good. Okay. All right, David Ortiz, please. Okay, counsel, announce your appearance for the record.
Philip Mendito on his behalf, Judge.
All right, so Mr. Ortiz, you have 2 capious misdemeanors, possession of cannabis under 20 grams, possession of drug paraphernalia, $2,500 bond on each one. These are 2017 cases.
Judge, the defendant hired me about a week and a half ago. I emailed the state to file a motion to withdraw the capious. I just hadn't heard back from the state to do that. He was interested in resolving these. The offer last time in drug court was a withholding cost.
That's what you're saying they offered?
They offered a withholding cost and an 8-hour class, Judge. I think spending the night in jail would be similar to taking that 8-hour class, but I don't think he has priors.
I'm fine with the withholding court costs.
Okay, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes.
All right. All right, it's my understanding your attorney, Mr. Mendito, is telling me that you want to resolve your case today and give up all your rights to a trial?
Yes, ma'am.
You can put your hand down. And your name is David Adam Ortiz, O-R-T-I-Z?
Yes, ma'am.
All right. How do you want to plead to, let me pull them up again. Count 1, possession of cannabis under 20 grams. Count 2, possession of drug paraphernalia. Guilty, not guilty, no contest.
No contest, David.
You're doing this freely and voluntarily?
Yes.
Under the influence of any alcohol, drugs, or medication?
No.
Ever been treated for a mental illness that would affect your ability to understand what's going on here today?
No, ma'am.
All right, court's going to accept his plea. Find that's freely and voluntarily entered. Court has reviewed the court file, finds probable cause for the plea, withhold of adjudication, and court costs of $308. 1 year to pay. Partial payments are accepted. Withhold on count 2, which is the possession of drug paraphernalia. The court takes judicial notice of the time that you served in the Broward County Jail. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you, sir. Good luck to you.
Thank you.
Thank you. Nice seeing you, Mr. Mendito. Okay, Mr. Weinstein, come on up. Nice to see you, too.
Judge, thank you for calling. I appreciate that. I was in the middle of a hearing, but I got your message.
I figured you would.
Thank you.
It's a good message I have, telling people don't hang up, because I almost did.
You cannot imagine the people who, like, they call 7 times when you're in the middle of a court hearing.
Yeah.
So.
I'm glad you had that.
Yes. Hi, Jermaine.
What's good, man? How you doing?
Do you need time to talk to him? You can call him on the phone. Okay.
No, I've read everything, and I already have an agreement with the state.
All right, so let me just tell you, sir, you're Jermaine Joseph? Yes?
Yeah, I think you hit the...
I think he hit the mute button.
Yeah.
Jermaine, unmute it.
Yes, ma'am.
All right, you want to waive formal reading?
I will waive formal reading. I will stipulate there is probable cause for the stop.
There was no stop.
All right, sir, you have an attorney here?
Jermaine,
so
it's Michael Weinstein. I'm here.
I don't think he sees you. Do you see your attorney?
Okay, I see him now.
Hi, Jermaine.
Right. Oh, hey, I thought it was muted. Sorry.
Okay, so leave it unmuted. All right, so what say you on count 1, the possession of cocaine?
Your Honor, we reached an agreement, 1,000 on 1, and he can be ROR'd on the remaining counts.
All right. So, 1,000 on 1, ROR on 2, 3, 4, and 5. Is your address 4040 Northeast 2nd Ave, Pompano?
Yes, ma'am.
All right, thank you. Good luck to you. Court finds probable cause.
Jermaine, call me when you get out.
Did we ever hear back from Ron Baum?
No, Your Honor.
Yes, Judge.
I contacted the detective. We can proceed on Mr. Jones's case. I have the information for the...
Okay. That's right. That's the gentleman. He's not representing him.
Yeah, not at this
Have a nice day, Mr. Weinstein.
Thank you, Judge. Goodbye.
Bye. Tell your dad I said hello.
I will. Are we on or off?
We can be off. All right, so, Mr. Jones, what are we doing with this state?
Well, I'll wait till he gets up. Your Honor, I spoke with Detective Martinez. The alleged victim is in her 20s, as I suspected, so.
All right, so let's go side. All right, what say you, State?
Your Honor, based on the allegations contained in the report, I'm going to be requesting a $75,000 bond on the first-degree felony. His criminal history, Judge, and it's really based on the allegations more than his criminal history. There's nothing very significant in his criminal history. And as far as Broward, in 2010, he had a DUI broken down to a reckless driving. He's had...
So anything of significance?
No.
Okay. Here you go, Mr. McLaurin. So just.
Thank you, Judge.
What say you, defense?
My concern would be this, Judge, before Mr. Romero gets into his ties to the community. I understand the victim is making an allegation that Mr. Jones drugged her and then these other acts took place, and that could be an explanation as to why her memory is so hazy. But this incident took place on September 29th of 2018. It appears that she was taken to the Nancy J. Cotterman Treatment Center, where a toxicology report was generated, or certainly an investigation as to what might have been in her system was attempted to be found. And I don't see anything in here about any drugs in her system at all. So I think that's something the court can take into consideration when determining the strengths or weaknesses of the state's case. It also appears that he surrendered himself to the Broward County Sheriff's, to the Fort Lauderdale Police Department.
Your Honor, I can advise the court. I asked Detective Martinez. They've not gotten the results yet back.
Well, I don't know why it would take from September 29th. Today is December 12th.
Because he absconded. Oh, you talking about?
No, he didn't abscond. He came back.
Okay, wait. I take that back. I thought you were saying the results from him.
No, the results from her.
I thought you were talking about DNA.
And Your Honor,
okay.
all Detective Martinez can do is have the evidence collected, have it brought to the lab.
There's nothing he can do till they get him.
Well, no, they didn't have to wait to get him. They had the evidence on September 29th to submit to the lab for a toxicology test. That's when the toxicology test was done. I understand Detective Martinez is not in charge of the lab, and I understand that the state attorney's office is not in charge of the lab, but the simple fact is that there's no evidence currently before this court to support the victim's allegation that there was some drugs involved or that she was in some way drugged. Now, that may change later on. I don't know. It may change later on to the extent that it's found that there's nothing in her system. But for purposes of bond in this particular case, and this is not a probable cause argument, I think there's probable cause to establish the charge, but I think the strengths and weaknesses of the state's case are something that the court can take into consideration when determining what an appropriate bond would be.
Okay, so you're saying that there was or there should have been a drug test, a urine test, a blood test or something?
There was, according to the report.
Where does it say that? Because it says...
It's...
Okay, I see, and toxicology. Okay.
Yes, ma'am. That's what I'm focusing on, is
I
that a
thought it was the
toxicology
word
test
before it.
was done.
Okay. All right, so I get your point. I'll give it the weight it deserves. What say you, State? Anything further?
Oh,
And then we'll let Mr. Romero go.
No, just noting that you did, the alleged victim did provide a sworn statement.
I don't have a victim notification sheet.
Well, Your
I
Honor,
don't see the initials here.
I advised the court they are, the initials are Bravo Sierra,
When did you tell me that? I didn't have it written down.
when the case was initially called.
Okay. All right. So court does find probable cause. Court's going to order no victim contact, direct or indirect, with the alleged victim with the initials BS and maintain 1,000 feet. minimum from the alleged victim. What say you, defense?
Judge, in speaking with Mr. Jones, the $75,000 which the state is suggesting is something simply beyond his financial means. He is 70 years old. He's on a fixed income. He gets Social Security. He gets approximately $1,600 per month. He does have a savings account in which he advised me he has $1,000 in that savings account, and he also has a checking account in which he says he has about $300 in that checking account. Judge, he's been living in South Florida in our community for the past 12 years. He was living in the same apartment in Fort Lauderdale for about 10 years, and his monthly rent is about $900 per month. Right now, Judge, my understanding, as the state did mention his priors, nothing of significance. All he has is basically a reckless and maybe a couple of trespasses or municipal ordinance offenses. So nothing nothing ever similar to this offense, nothing any violent charges or anything like that in his past. My understanding, Judge, he is a veteran. He served in the United States Army from 1968 through 1970, Judge. Right now, from what he advised me, unfortunately, he has no family, no one that can help post his monetary bond. His best friend, unfortunately, passed away earlier this year. So, unfortunately, he has no one to turn to at this time to assist him with posting a monetary bond. Judge, I do understand the allegations, but Mr. Jones is looking forward to having his day in court and disputing these allegations. As my colleague mentioned, he did surrender himself. He's not a flight risk. He assured me he's going to come to each and every one of these cases to make sure that his rights are always protected, and he wants to go ahead and fully, with his attorney, fight these allegations. So, Judge, having said all that, I'm going to be asking for $10,000 on Mr. Jones's behalf as far as a monetary bond. And also, Judge, we would not object as far as having him also be supervised by pretrial release.
All right, no victim contact, direct or indirect, maintain 1,000 feet minimum, GPS level 2, $25,000 bond. Thank you, sir. Good luck to you. Corey McMahon. Sir, good morning. You have driving while license is suspended, first offense. Court does find probable cause. My understanding, sir, your bond posted 3841 Jasmine Lane.
Which one? Can you repeat it again, ma'am?
Sure.
Thank you.
3841 Jasmine Lane.
Yes.
All right, look for your court date. Good luck to you.
Can we resolve it? Oh, Judge, he's asking. Can we resolve it today? The court would consider
We
resolving
have
it.
your driving. You know what? I'm not going to resolve it. It's his first offense. Let him get his driver's license fixed and whatever it is he has to do. Thank you, sir.
Thank you so much.
Try to show up to court. Let me see. Hold on a second. Give me his driving record. Let me just see what's going on with this driving record. Maybe we
It's
can-
on a 893 suspension.
Oh, for how long?
He was a year from May of this year.
All right, so maybe.
No, I'm just saying that it's
Okay.
not based on failures to appear.
Okay,
or
that's fine.
failures to obtain.
So it's an 893 violation. He's got one more year to go. A year and a couple months. Thank you. Jerome Lenore. Bonded. Court
Mr.
finds
Ferreira,
probable
you
cause.
should be next.
Fernando Ferreira. Main jail. Mr. Ferreira, you have DUI alcohol or drugs, first offense, $500 bond. DUI unlawful blood alcohol level, .177 and 169. You blew over .15. Court finds probable cause. Does he have priors?
1 moment, Judge.
I don't think you have any, Mr. Shate. Mr. McLaurin said he's doing Oakland Park. You see any state?
I'm checking, Judge.
Okay. I'm sorry, I didn't know if you said something maybe.
Oh, yeah, no.
Because I was talking to Mr. Shate.
That's okay. I know it's...
Yeah. 2 cases.
No prior, Judge.
Okay, ROR, sir, good luck to you. Hold on just one moment, sir. Is your address 3430 West Hillsborough, 204?
Yes, ma'am.
Thank you, good luck.
Your Honor.
Yes, Mr. Shade, yes.
Yes. I just contacted the detective. The victim's at large. So that would effectively keep him in custody.
All right, let's call Mr. Jones back, we need him back.
Mr.
Can I have the paperwork on Jones? I need all of it, please. Yes, Mr. Shade.
Judge, I have one this afternoon, I'll come back. Tony Sherrod, I guess he's in court somewhere else, so
Yeah,
I'll come back and handle that one.
all right. We don't see you, we'll call you.
Okay, I'll be here.
We know where to find you. Okay. You can run, but you can't hide, right, from us? Okay, all right. Do you have the paperwork? Ms. Patrice? Or Mr. Jones? John Jones. Did I sign paperwork? Okay, we need it, I need it back, everything back. You're gonna write it in there?
It's already written in, I would just cross it off and give it back to the.
All right, let me, because I want to write on there. Okay, Mr. Jones?
Yes.
All right, I'm going to delete the requirement of a minimum of 1,000 feet per the state attorney and the law enforcement officer in this case. The victim is at large, so here's the thing. If you see this victim, sir, I want you walking the other way. I don't want you saying anything. I don't care if you're at the Publix checkout line getting your groceries. Just make sure that you leave, okay? Immediately.
Yes.
Okay, so I signed it all. I'll initial this. Here you go, Miss Patrice. Thank you. Make sure this went through. Okay, there you go. Thank you. Sorry about that. Christian Presley, please.
Mr. Presley, come on up.
Okay, Mr. Presley, you have an ad charge, armed carjacking or carjacking with a firearm, armed. Court finds probable cause.
I provided the court with and defense counsel with a supplemental report.
Sure.
Your Honor, based on the allegations and Mr. Presley's admissions, I'd be asking the court to make a finding of proof evident or presumption great at this time.
Okay.
And hold him no bond.
Mr. Presley is currently being held no bond on an out-of-county hold. Therefore, we would defer any argument regarding proof evident presumption great until such time as Mr. Presley can appear before his division judge, which I believe is Judge Coleman.
Yeah, I don't have a date here that he's going before Judge Coleman. Anybody know why? Shouldn't he be going before him? Or is it not on these type of cases?
One moment, Judge.
Because this is a juvenile capias. All right, so in the meantime, Mr. Presley, I have reviewed the affidavits and the capiases and other documents filed in your case, and I find probable cause. I further find the proof of guilt to be evident or the presumption great. Therefore, sir, you're going to be held no bond pending further order of the court. This order is without prejudice for you to file a motion to set bond with your assigned division judge and request a hearing under State v. Arthur. Therefore, you're going to be held no bond. Defense deferred argument on proof evident presumption. Great, yes.
He's been scheduled for arraignment on this case next Tuesday.
All right, so you'll see your judge next Tuesday in front of Judge Coleman for an arraignment. Thank you, sir. Good luck to you. Jeffrey Finley. Good morning, Mr. Finley. You have false ID given to a law enforcement officer, $100 bond. Count 2 is resisting an officer. Obstructing without violence. No bond required. Probation violation or community control. No bond hold. You do have an out-of-county hold. Felony and misdemeanor. One is a no bond on the felony. The out-of-county hold on the misdemeanor is a $5,000 bond, and you have riding a bike with no light. Court finds probable cause, and by the way, it's out of Hillsborough County, is where the hold is out of. Let's see if there's another county. They're both Hillsborough. It's actually for the misdemeanors for a failure to appear for driving while license is suspended, second violation. What say you, defense?
Judge, considering he's on probation in Hillsborough for a felony offense and he has a current misdemeanor offense, we can't resolve it. Will you be asking the court to consider as an R watch so that Hillsborough can come pick him up on the misdemeanor?
I don't have an objection.
Okay, per state and defense, ROR on count 1. Terrence Morris, please.
Mr. Morris, come on up.
Morning, Mr. Morris. You have burglary, unoccupied conveyance, unarmed, 3 counts. Court does find probable cause. Court's going to order no victim contact, direct or indirect, with the alleged victim with the initials TFC and CDMH. What say you, State?
Moment, Judge. In a moment.
We get the afternoon docket yet? How many second looks do we have? A lot. Okay. Huh? How many? Plus 2 more. 15. We have 15 second looks today.
Some of those are motions to release.
Okay, good. Well, they were on the second look docket, so I'm just letting you know.
Yeah, nice. Your Honor, I'm going to be requesting $7,500 bonds on each count, pretrial release of the GPS monitor.
Okay.
The reason being, Mr. Morris is a registered sex offender, and from a 2001 case, he was convicted of attempted sexual battery with a weapon or using force, aggravated battery, and false imprisonment. Was sentenced to 15 years probation. He is not on probation at the moment. But my other concern, he's also in 01 was convicted on a separate case of aggravated battery with a deadly weapon. As the court is aware, if he is convicted of these charges and faces any sentence that involves any type of incarceration, he could potentially face involuntary civil commitment.
Jimmy Rice, you mean?
Yes, ma'am.
Say your defense.
Judge, if my math is correct, the $22,500 bond is something Mr. Morris cannot afford. It is true he has a prior, but it's when he was about 13 years old, Judge. He did serve time. He got out of prison in 2016. Since then, Judge, 2 years, he's basically changed his life around. He is working. He has a family. He's currently, right now, he's 31 years old. He's worked 2 jobs trying to support his family. One job that he does is he works for Southeast Landscaping Company. He's been there for over 3 months, making about $10 an hour. That is a part-time job, Judge. So whenever he can get hours, that's where he works. and right now he's currently also employed. His second job is American Life Insurance. He's going through their training program to become one of their certified agents. He just got that opportunity approximately 1 month ago. I believe they're paying him during this time, and he's getting about $350 per week. Right now, he lives in Fort Lauderdale, Judge. He lives with his aunt.
What's that address?
Ma'am, I need to look at my cell phone to get it. I don't know the exact complete address.
What street is it on?
It's in Washington Park Drive, Washington Drive.
Okay. Go ahead, Mr. Romero.
He's been living there for 4 months now, Judge. He lives there with his aunt, and she's a caretaker. Right now, Judge, he also, one of the good things about when he got out of prison, he met his significant other. They're engaged, and they just had their child. Right now, he's actually the breadwinner and helping her support his newborn child, Judge. He needs to be out there working so he can provide for his family. But unfortunately, from what he advised me, his family's not in a position to assist him with any sort of monetary bond. He's here before you on 3 third-degree felonies, Judge. Usually the standard bonds are $1,000 each. That is even too much for him. Judge, he's going to be asking the court to consider releasing him on pretrial release, and that is what the defense is asking for at this time.
And there is no standard bond for burglary of a conveyance.
All right, so $2,500 on 1, $1,000 on 2, $1,000 on 3. No victim contact, direct or indirect with TFC, CD, MH. GPS level 2. No return to 820 Northwest 13th Avenue, Fort Lauderdale, Florida, and maintain 1,000 feet minimum.
Yeah, it's on the second page.
Case SJR. So no victim contact. Thank you, Ms. Patrice. With another victim, SJR. Thank you, sir. Good luck to you. Addison Jones.
Mr. Jones, come on up, please.
See, I'm pretty trying.
He's approaching.
That's fine. No problem. Thank
I
you.
don't have 4 or 5.
Okay, Mr. Jones, you have battery on an officer, firefighter, EMT. We need to talk about bond, resisting an officer, obstructing with violence. We also need to talk about bond on that, trespassing, occupied structure, or conveyance. $100 bond. Counts 4 and 5 are violations for pretrial felony. They're not for magistrates. You have no bond holds. Court's going to order no return to the mobile gas station, 2123 North Andrews Avenue in Wilton Manors, Florida. Go back there, you will be arrested. Do you understand?
Yes.
All right, what say you, State?
Your Honor, I'd be requesting a $3,500 bond on 1, a $1,500 bond on 2, based on the allegations that he punched one officer in the face. And considering that he was out on pretrial for felony battery due to priors and resisting with violence, he's also previously been to prison for violating probation on a battery on a law enforcement officer.
Okay. What say you, defense?
Judge, I do understand he has no bond holds on 4 and 5. We're going to be asking for a $1,000 bond on count 1, $500 bond on count 2. Unfortunately, he's not working. He gets disability. And he's been here almost his whole life. He is 31 years old. Most importantly, Judge, that'd be second time. Okay. Judge, most importantly, we're going to be asking for a photo order so we can photograph the injuries that Mr. Jones sustained.
No problem with the photo order. $3,500 on 1, $1,000 on 2, $1 on 3. 4 and 5 are not for magistrate. They're no bond anyway. No return to mobile gas station and maintain 500 feet minimum. GPS level 2. Thank you, sir. Good luck to you. Preston Honeycutt. And after this, I got to take a break.
Mr. Honeycutt is here.
All right, good morning, Mr. Honeycutt. You have petty theft, second degree, third subsequent offense, so it's a felony even though it's a petty theft. $750 bond. You do have a probation or community control violation. You are going before your division judge, Ernest Calra. You're going to be held no bond. pending a hearing tomorrow in front of Judge Collier at 8:30. Thank you, sir. Good luck to you. Okay, we're going to take a break. What about Andrew Coffey? Where is he?
He was in a hearing with Judge McCarthy.
Okay,
He said he would get here as soon as he could.
okay. Well, hopefully he'll get here on time. I don't know, can you text him maybe?
Yeah, let me try to call him.
Ricky Ditzel.
Sure, ma'am, Your Honor.
Hello.
Good morning, Your Honor.
Good morning. All right, Mr. Ditzel, you have trafficking in fentanyl between 4 and 14 grams, $75,000 bond. Count 2 is distribute or deliver oxycodone, $2,500 bond. The court does find probable cause. What say you, defense?
Judge, there's no way Mr. Ditzel is going to be able to afford the $75,000 for count 1. My understanding is he had contacts with the criminal justice system, but they're quite dated from what he advised me, over 20 years. He's 49 years old, been living here in South Florida for the past 15 years. At this time, he is looking for stable employment. What he does in the meantime is odd jobs, whatever he can find, a handyman, washing cars, whatever it can be. Judge, fortunately, at this time, he was provided assistance through the United Way. He was given basically accommodations. He's residing in Hollywood, and those accommodations kind of came through about a week ago, where he's living in an apartment with his wife. He was previously living, I believe, he was homeless. He was living at the downtown Fort Lauderdale, the library, what some people refer to as the tent city. And he was relocated, and he was provided assistance as far as housing, unfortunately, and that's where what he has right now. His wife, unfortunately, from what he advised me, is ill. She's not working, and she doesn't have any sort of assets or money to post his monetary bond. From what he advised me, though, Judge, he is a registered voter here in Broward County.
Okay.
So, Judge, the only thing that we're going to be asking for is, since he has a place to stay, level 2 free trial.
State, what's his priors?
He has an old trespass. That being said, Your Honor, if convicted on count 1, he faces a 3-year minimum mandatory prison sentence. So the state would be opposing an outright ROR to pretrial, even with level 2.
Okay. All right. Any other special conditions besides a GPS?
No, no, not at this time, Your Honor.
All right. This is what the court's going to do. $25,000 bond on 1, $2,500 on 2, GPS level 2. Thank you, sir. Good luck to you. Johnny Clark, please.
Mr. Clark, come on up, please.
Okay, Mr. Clark, good morning, sir. You have an aggravated battery caused bodily harm
Good morning.
or disability, criminal mischief, public phones, cables, fixtures, equipment, etc., and harm to public servant or family. Court does find probable cause. Court's going to order no victim contact, direct or indirect, with the alleged victims with the initials KPP and LRA. What say you, State?
Your Honor, based on the level of violence that's alleged in this case, and it appears the allegations are that the victim was struck with a bottle and suffered large lacerations and significant blood loss. In addition, Mr. Clark has a pending possession of cocaine. In 2011, he had a shooting at or throwing a deadly, 2012, shooting at or throwing a deadly missile, sentenced to just under 6.5 years state prison. He was released August 20th of 2017. He also had an 09 of burglary with damage to a structure or dwelling. He violated probation, received the same sentence. I'm going to be asking for a $15,000 bond on count 1.
Okay, what say you, defense?
Judge, he's 27 years old. He's working right now. He works at Ross, He's been there for about 9 months now. He makes $8.30 an hour. He lives in Hollywood with his grandmother. His grandmother is on a fixed income. She gets Social Security. His portion of the rent is about $240 per month. Judge, we're going to be asking on count one for a $2,500 bond, and we'd have no objection to having him supervised with pretrial release on top of that monetary bond. Also, we're going to be asking for a photo order.
All right, no victim contact, direct or indirect. Should I do it with LRA? That's the officer.
I was just going to be asking for KP, Judge.
Okay, I'm gonna remove LRA. GPS level 2. Now, are these two neighbors, or I'm trying to look at this. 40 Pembroke Road. What's your client's address?
4050 Southwest 19th Street, West Park, Florida 33023.
Did the court hear that?
Yeah, thank you. Are you doing a Google map?
About 0.2 miles.
So the victim was in front of the defendant's house, which I'm not justifying it, but I'm just saying.
Yes, it would appear this happened outside the defendant's home. And it's about a little over 1,000 feet between the two residences.
All right, I'll do 500 feet minimum distance with KPP. GPS level 2. Court will set bond at $5,000 on 1. ROR on 2. On 3, I'll do a $1,000 bond. Total is $6,000. Thank you, sir. Good luck to you. And sir, you have to pay your bond first before they'll fit you with the GPS. Jason Pinnell.
Excuse me, ma'am. There's no way I could get $600. There's no way at all. Can we do a little lower? I mean, it's
How much can you afford?
I can afford $400. There's no way I can get $600.
Your Honor, I think the bond that the court said is reasonable as it is, considering his history, considering the allegations. And then, and I didn't mention it, but then later on, he's threatening to kill the arresting officer's mother.
All right, I'm going to leave them where they are. Let him go before his division judge, and maybe you can make some phone calls for him, Mr. Romero, and help him out. Thank you.
Mr. Coffey will be here in a couple of minutes, Judge.
Thank you. Jason Pinnell. I need to know his priors.
Yes, ma'am.
Okay, Mr. Pinnell, you have possession of cannabis, 20 grams or less. No bond required. Possession of controlled substance without prescription, $1,000. Possess and or use drug paraphernalia. It's a misdemeanor. Or it's not even, it says NA. Why would it say NA? Why wouldn't it say NC? Both of them say NA. So I'm going to change it to NC, which means no bond is required, no charge. What's his prior state?
Last month, trespass in April, theft 2016, possession of cocaine, carrying concealed weapon 07, alprazolam 06, a year and a day. He's had prior grand thefts, burglary, showing 13 prior failures to appear. Most recently, he was arrested in Davie, April this year on a failure to appear.
All right, what say you, defense?
Judge, from what Mr. Purnell has advised me, no one can afford to post his monetary bond. He lives locally in Davie. He's looking forward to his day in court. Judge, we're going to be asking for an ROR or supervised with standard pretrial release.
All right, I'm going to give him standard pretrial supervision. Not going to release him. He does have a lengthy criminal history, or not the greatest. Let him report within 24 hours of his release. Does he need a place to live?
Yes, I believe.
Does he want to go to? Absolutely, take your time. Mr. Coffey, how are you?
Good, Judge. I'm so sorry.
You have 2 cases today, right?
I only knew about one, but maybe.
Elliot Glasser and Jessica Lopez
Oh, they're
Gomez.
together? Oh, yeah, no, I know them well.
All right. So give me a moment. We just have this one. If you want to talk, I don't know where Glasser is. Mr. Romero, let me interrupt you for one moment. Where's Mr. Glasser?
He's sitting back there.
He is?
He's here, Judge.
All right, what about Jessica Lopez Gomez?
Pompano, I believe.
Okay. All right, so thank you. So, Mr. Coffey.
Yes, Judge. I'm just quickly reading.
You want some water? Well, we have Mr. Coffey here, so let's wait till.
Sheila.
You ready?
Yes, Judge. I did advise him, and respectfully, he's going to, at this time, decline the centralized receiving center.
That's fine. All right, so he has to report within 24 hours of his release. No, he doesn't want to go there. So standard pretrial supervision, report within 24 hours of your release. Says here that he has a West Palm Beach address. What's his mailing address?
Do you have a mailing address?
That is my mailing address.
He could get
What
mail
is
there,
it?
Judge.
That is my mailing address.
What is it?
13529 Orange Grove Boulevard, Royal Palm Beach, Florida, 333411.
It says West Palm Beach. Is that okay?
Yeah.
All right, if it doesn't go there for some reason, then you have to look it up online. You can go to the clerk of court. You can also ask pretrial services. So I'm going to have him call in twice a week, report within 24 hours of his release, explain to him what happens if he violates. He'll get a no bond hold. He doesn't show up. I'm only going to have him report after he appears in court. So let's say, Ms. Patrice, I want to say appearing. Let's say he doesn't have to go to the hearing, then he doesn't have to appear. All right, you understand that, sir?
Yes, ma'am.
All right, good luck to you. No bond required. Okay, and you just need to add Boulevard to his address. Okay? Okay, Elliot Glasser, page 21. Busy morning?
Yes, thank you for your patience, and thank you,
No
Mr. Reedy,
problem
for
at
keeping
all.
me abreast of everything.
Yeah. All right, so it's page 21, Elliot Glasser. Can you see your attorney?
Yes, Your Honor.
Okay. So you have robbery, no firearm or weapon. We need to talk about bond. Count 2 is grand theft between 300 and 5,000, and count 3 is commit theft, resist recovery of property. Total bond is 1,100, plus we have to talk about bond on count 1.
Your Honor,
Or,
I'm sorry, first on count 1, I spoke with Mr. Coffey, and I think we're both in agreement that it should be robbery by sudden snatching.
okay, so robbery, PC, state defense.
And
Anything else with regard to PC?
I think that's...
No, Judge.
All right, so the court finds probable cause. Court's going to order no return to the Home Depot at 750 North University Drive, Coral Springs, Florida, and no victim contact, direct or indirect, with the alleged victim in this case, whose initials are CMS.
Your Honor, I think we also have an agreement as far as bond.
Sure.
We've agreed to $2,500 on 1, $1,000 on 2. I have no objection to an ROR on 3, since that kind of is included within the allegations in count 1.
Okay.
That's fine, Judge.
All right, so no victim contact, no return to Home Depot. 2,500 on 1, 1,000 on 2, per state and defense for all these bonds, and ROR on 3.
I'll call Daryl.
Thank you, sir. Good luck to you.
Okay. Elliot, I'll call Daryl and have him bond you out.
Total of 3,500. Sir, you keep hitting that button. You just have to hit it. He didn't hear what you said.
Thank you, Andrew. What about Jessica?
That's next. Don't.
Do I need to bond out, or how do I?
Yeah, I'm gonna call the bondsman for you.
All right, thank you.
You're welcome. Thank you, Judge.
All right, next one is Jessica Lopez Gomez.
No problem, John.
Announce your appearance for the record.
Andy Coffey on behalf of Jessica Lopez Gomez.
All right, so she has grand theft between $300 and $5,000. Bond set at $1,000. What's her prior state?
Your Honor, I don't see priors, and I discussed this case with Mr. Coffey as well. I'm going to be asking the court to keep the $1,000 bond in place for a couple of reasons. One, I would note, based on the information provided by the loss prevention officer, and it does say he gave a sworn statement, that he recognized Ms. Lopez Gomez from previous thefts at this same location. I would also note, Your Honor, and it's not on the findings or the booking, but she has been charged with an immigration hold, and she's being held on that at this time.
Judge, I did see in the police report that at most, that she was the driver. And I think there was even a line here that...
Tell me which page you're on,
Oh, sure,
because there's
Judge,
a
let me
lot
just-
of pages here.
Yeah, I know. Hold on one more. Yeah, this is on the last page of her report.
1, 2, 3, 4, 5.
It's the second paragraph. It starts off, it is believed that Lopez Gomez.
Yes.
So that's what I would just point to in terms of arguing against the, not that the bond's not unreasonable, but I would just ask you to consider maybe an ROR. Again, I know she's not going anywhere because she has the immigration hold. And, but I do think that this, in reference to her alleged actions, they seem to be minimal at best, and not even, even the officer himself or herself indicated that it just seemed like Lopez Gomez was working in concert with Laser as the getaway driver. So,
And Your Honor, I was referring to page 3, the first sentence, the second paragraph, where the loss prevention officer advised he recognized the driver of the vehicle as the girlfriend of Joseph DeLuca, who's a known shoplifter or had involvement in prior retail thefts at Home Depot.
Well, has she been charged with prior thefts?
No, Your Honor, but it's clearly, and that's why I mentioned, this loss prevention officer is giving a sworn statement. He's making it a point of telling the officer that he recognizes her from these previous incidents. I'm not asking for a bond increase, but considering that she has a no bond hold on count 2, and it appears this appears to be repeat activity at this same location.
I'm gonna leave the bond at $1,000. She has an immigration hold anyway.
I understand. I just want to make my argument.
All right, no return to Home Depot. Thank you, ma'am. Good luck to you.
Thank you, judges. Always a pleasure.
Thank you. Do you want to speak to her and tell her what's happening? No? Okay, thank you. Mauricio Malasani.
Bonded.
Thank you, Mr. Reedy. Court finds probable cause. Moving right along.
Yes.
Paul Kennedy.
Mr. Kennedy's here.
Main jail.
Yes, he just went to the restroom.
Okay. Johnny Lee Allen, please.
Mr. Allen, come on up, please.
By the way, we have a lot of second looks today.
Have a seat, Mr. Kennedy.
I'm doing good. You have grand theft between $300 and $5,000. No return to the Home Depot. At 60 Southwest 12th Avenue in Deerfield Beach, Florida. If you go back there, you will be arrested. Do you understand?
Yes, ma'am.
Okay. What's his prior state? Anything significant?
Your Honor, just so you know, Mr. Allen is currently being supervised by pretrial services in case 18-13344 CF10.
For what?
It's for a grand theft also. I don't see that case is filed, so that's the reason why I'm not asking the court to revoke his pretrial at this time. I show in Odyssey where it says states notice to delay finding. So I'm just letting the court be aware of that. Had I not seen that, I would have asked for it.
And I can advise pretrial, it's going to be filed. I see it was actually updated yesterday, an intent to file grand theft auto charge.
And he's on pretrial supervision, Your Honor. He was placed by this court on the 29th of October. So based on this court final, probable cause we're gonna access pretrial services.
All right, what say you?
Judge, in speaking to Mr. Allen, my understanding is he did inform me that he was out on pretrial, standard pretrial on that one case. Right now, he did advise me as $1,000 bond. He told me he cannot afford to post that bond. He's 39, been here his whole entire life. He does work off and on for a moving company whenever there's work. My understanding is they give him a call and he can show up and get a couple hours. Unfortunately, he is homeless. Now, he did advise me that he has his mother residing here in Broward County, specifically in Pompano Beach. He says he's going to try and reach out to her to see if he can reside with her. And based on that, Judge, then I'd ask Your Honor to consider releasing him on level 2 pretrial release up to level supervision on the case that he's currently out on 18-1334 CF10A from standard to level 2 pretrial. And that's what the defense is asking for at this time, Judge.
I would just add, Judge, it appears as though Mr. Allen put down the item that he was attempting to steal. I don't know if that reflects a change of heart or what it might have been. And it also appears Mr. Allen doesn't do a very good job of getting along with his co-defendants as they drove off and left him behind. So I think that those are facts that maybe the court could also consider in determining appropriate conditions for Mr. Allen's release.
Okay. Under revoke his pretrial 18-1334 CF10A. Even though it hasn't been filed yet, the state did say there's an intent to file. I'm gonna set the bond at $1,000 and leave it at $1,000 on the grand theft. Thank you, sir. Good luck to you. Paul Joseph Kennedy.
Yes, Your Honor.
Mr. Kennedy, you have possession of heroin, possession of cocaine, $1,000 each. Drug paraphernalia, possess and or use $100, total $2,100. Court finds probable cause. State, does he have any priors?
He has, one moment, Judge. (2010) out of Indian River, possession of oxycodone and alprazolam with intent to sell or deliver. Most recent I see.
Where's your client live? It says he's at large.
Judge, from what he's advised me, he's living in Plantation.
I'm at Omega, Building 2.
What's the address?
I believe it's 1070 Southwest 16th. It's either 1070 or 7100. I got the numbers mixed up in my head. I'm staying with my roommate, Mark.
How do you support yourself?
I work for Reliable Asphalt Paving and Seal Coating Company, and I just started working for 7-Eleven part-time. But I cannot afford any bonds. I have no one out here local to help me post or anything.
State, what's your position?
I have no objection to non-monetary release.
Okay, standard pretrial supervision. Sir, I'm going to tell you, and I'm going to put it down here. Defendant advised to update his address in writing with case number within 5 business days. So that would be by next Tuesday, okay, at the clerk. And copy your attorney, the public defender. I'm assuming you're not going to get a private attorney since you told me you can't afford a bond. If you violate pretrial, you're going to be here on a no bond hold. Why is he not listening to me?
He said he's not feeling well right now.
Part of what you said about reporting the address. Did you say it's downtown to the courthouse?
I'm going to put you on standard pretrial supervision. You're going to report within 24 hours of your release. If you don't report, I'm sure your division judge will issue a no bond hold. You're going to call in 4 times a week, report once a month.
4 times a week, once a month.
In person. I'm advising you to update your address in writing within 5 business days of the clerk of court. You can go to the clerk of court in Plantation. You can go to the one in Hollywood, Deerfield, or the main courthouse. And also give a copy to your public defender along with your case number. You can also check with the browardclerk.org. If you don't have access to the internet, you can go to a public library. Okay? You can call the public defender. Hold on, I'm not done. You can call the public defender, and you can also check with pretrial services.
Thank you.
Yes, sir. What was your question?
One gentleman was homeless. I might want to change places of where I stay, where I reside. And if I don't have the monetary resources to do that right now either, would I be able to get the information about that place you're talking about, that other gentleman that helps with housing assistance?
Oh, the centralized receiving center.
Yeah, that's different. That's, all right, I'll take that back. I'm sorry.
If you want, they help you find housing. We could have you transported there. Pardon?
Is this somewhere I could visit though in the community after I get released that I go to personally?
Yeah, they could take you there 9 a.m. tomorrow morning.
If I decide to move, I'm saying, but...
All right, that's fine.
On my own?
No problem. Mr. Romero can give you the information.
Okay.
Thank you. John Farrells.
Medical reset.
Where is he? Antoine Carter.
while he's coming up, Your Honor, I believe one of the burglary counts should be an attempt.
Okay, which one?
Whichever one, it could be,
You pick it, it's your case.
charge 8.
Charge 8, first state and defense, attempt only. You agree, Mr. Reedy?
I do.
Hey, are you Antoine Carter, sir?
Yes, Judge.
All right, you have possession of burglary tools with intent to use, $1,000 bond, burglary unoccupied conveyance, unarmed, petty theft, second degree, first offense, $25, driving while license is suspended, first offense, $100. 5 is tag, obscured, unsecured, or none, that's not for magistrate. Violation of probation, no bond hold, count 6. Count 7 is possess burglary tools with intent to use, that's the same as 1. And count 8 is attempted burglary, unoccupied conveyance, unarmed. Count 9 is a probation violation or community control. The court does find probable cause. As stated. What say you, State?
Your Honor, I'd be requesting a $5,000 bond on 2, $2,500 bond on 8, noting that he's on probation at a date for burglary of a structure and grand theft.
He's got a pending case?
I'm sorry, Your Honor?
Pending Miami-Dade case?
Well, he's on probation at a date on those charges. And I apologize, did the court order no return to Sawgrass?
I didn't order anything yet.
I'd be asking no return to Sawgrass Mills.
Okay, give me the address.
12801 West Sunrise Boulevard in Sunrise.
Any particular store?
Your Honor, these were in the parking lot, so I'm just going to ask at this time until further order no return to Sawgrass Mills. Might be in the afternoon document.
Did you hear that, sir?
Yes, I heard it.
Okay. All right, what say you, defense?
Judge, Mr. Carter is not going to be able to quite come up with the $9,625, which is say you're suggesting. We're going to be requesting a $1,000 bond on count 2 and a $1,000 bond on count 8. That would be a total of $1, 2, 3, $4,000, and I'm going to be asking for an ROR 3 and 4. I do realize he has no bond holds out of date, so even if he posts a monetary bond, he's not being released. He's going to be transferred to Dade County. He's 30 years old, Judge, or living here his whole entire life. He is working. He works part-time at a cleaning company called MG Cleaning. He's been there employed for the past 6 months, making $8.50 an hour. He lives in Miami with his father. Right now, his father is working at Publix, Judge, and their monthly rent is $1,050. Judge, that's what the defense is requesting for at this time.
$1,000 on 1, $3,500 on 2. 3 and 4 are $1 each. 5 is not for magistrate. 6 is no bond hold. 7 is 1,000. 8's 1,000, and 9 is a no bond hold. Thank you, sir. Good luck to you, and no return to the Sawgrass Mills Mall. William Jones.
Mr. Jones, come on up.
Morning, Mr. Jones. You have a petty theft, second degree, first offense, $25 bond. Court does find probable cause, bond set at $25, and No bond hold on count 2. He is going before his division judge, Judge Edward Merrigan, tomorrow at 8:30 a.m. Court will set bond at $1 on count 1. No bond on count 2. No victim contact with the alleged victim with the initials RM. Come on up, Michelle. You don't have to. Oh, thank you. I'm almost done. I have one left, so. Next one is Ryan Scott Cuppinger.
Come on up, Mr. Cuppinger.
Okay, Mr. Cuppinger, you have touch or strike battery, $1,000 bond. Count 2, criminal mischief over $1,500. Count 3, resisting an officer, obstructing without violence. No bond required. The court does find probable cause. Court's going to order no victim contact, direct or indirect, with the alleged victim with the initials AA. What say you, defense?
Judge, we're going to be asking for the court to consider releasing him ROR on the alternative on standard pretrial release. Right now, unfortunately, he just lost his job. He was working at Capitol Grill as a server, making about $5 plus tip. He's right now enrolled to start, I believe, in spring semester at Miami-Dade College, where he's going to be studying physics. He's 31 years old, been here for 6 years. He's currently living at Wilton Manors. He's been there at that location now for about 4 years. He lives there with his roommate. Judge, my understanding is limited contact with the criminal justice system. So my understanding is that the alleged victim, I believe, is an office manager or an office worker of the apartment complex where he lives at. He assured me that basically no need for him to have any sort of contact. I believe the victim works in the office from 9 to 5. Mr. Coppinger can go ahead and there's no reason why he would need to go to the office. Any messages he has to address with the office, he could have his roommate do it or pay rent. He could have his roommate give it the check. So he's going to abide by the court order as far as no contact with the victim, but we're going to be asking for an ROR or pretrial release on his behalf.
Well, I don't know if the victim was living with him, because it says, and it's going to be an...
Your Honor, I can tell you what Mr. Romero is advising the court of would seem to make sense. The allegations are it occurred in an office. The victim's address, it's showing at Oakland Park.
I understand, but it says here, was responsible for the willful blah, blah, blah of the victim's computer and malicious office equipment by pushing his computer and equipment off of his desk.
Yes, and it says, the next sentence, due to the defendant's actions, a scuffle between, I guess, the defendant and the victim ensued, which resulted in a damaged wall inside of the victim's office.
Where did he attend school previously?
Where did you attend school?
I did attend college before in Georgia. That was many years ago, and so I'm going back now.
Okay. All right, State, what say you with regard to no monetary bond and standard pretrial? Okay. Hi, it's Kim Malika. How are you? Good. I'm on my last case. I'll come down there because I'm actually in the first appearance courtroom. Pardon? First floor? All right, I'll be down there. I'll leave here in about 5 minutes, okay? Thank you. What time does it begin? Can you believe this? It's ready. They said December 31st.
I've got some additional information, Your Honor.
Okay, good.
One, I can advise you, I just spoke with Mr. Acevedo. He does work in the office. What he has advised me is he is concerned about the court.
Who's he works in the office? Mr. Acevedo?
Yes, Angel Acevedo.
Okay.
He has concerns about the court just releasing Mr. Cuppinger ROR or to pretrial. He advised me, one, that there's been previous incidents where Mr. Cuppinger has acted with violence and with hostility. He told me there was an incident when he got into an argument with another couple and he at one point started swinging at them. There's been previous incidents with Mr. Acevedo where he's acted hostile. He's also advised me, and this really has more to do with where Mr. Cuppinger is going to reside. He advised me Mr. Cuppinger has an application, but he is not technically on the lease at this apartment. And he's advised his roommate that if Mr. Cuppinger comes back to that apartment, they will be initiating eviction proceedings.
I get it. So what is it that you're asking?
Your Honor, at this point, I'd be asking.
I mean, I'm more concerned about him going back there.
Yeah, no,
than posting $100 on a bond.
I understand, Your Honor, and I mean, look, the bond amount the court sets, it's up to you.
I understand.
You know, there's no rule that says it has to be kept at 1,000. It's what's reasonable based on all the factors. I think 1,000 is not necessarily unreasonable considering the information I provided, but also taking into consideration his financial resources. Having him simply call in, a couple times a week and checking in once a month also isn't necessarily going to address the concerns about if he goes back to this complex.
All right, that's what I'm willing to do. No victim contact, direct or indirect with AA, unless he wants to pay the $1,000 bond. And that has nothing to do with the victim contact. I'm not allowing him to return there except with law enforcement.
That's what I'm also advising him right now. He wishes to accept pretrial release and he'll adhere by the conditions. I already informed him, gave him a heads up, there's not going to be any sort of return, except for, I believe, one time with law enforcement to retrieve his property.
Correct. All right, so no victim contact, direct or indirect with AA. No possession of any firearms, ammunition, or weapons. If you do have any, you're to surrender them within 24 hours of your release to your local law enforcement, or police department, I should say. Allowed to return one time with a law enforcement officer to retrieve belongings. That doesn't mean that your roommate can't help you out and deliver belongings to you. And there's standard pretrial supervision. You have to report within 24 hours of your release. Call in 4 times a week. Report 1 time a month in person. Okay, that's it. Also, you're gonna have to update your address. I don't know if you heard me speaking to other people. You're gonna have to go to the clerk of the court and the public defender. You don't have to do it before your court date, but you can look online, because obviously it's gonna go to the address of 220 Northeast 24th Street. .520 Northeast 20th Street. Obviously, he's allowed to go back there with law enforcement 1 time. Or Northeast, I'm sorry, 20th Street. Wilton Manors. And I want him to maintain 1,000 feet minimum. Thank you, sir. Good luck to you. All right, see everybody back for lunch.